I'm Dr. Barbara Sharif, State Senator for District 35. I'm speaking today on behalf of the Pattersons and countless other families across Florida and this nation whose lives have been torn apart by wrongful child abuse accusations. Cases where specific documented medical conditions mimic signs of abuse. These families are trapped in the Department of Children and Families system, losing their dependency cases and in too many instances, their children forever. The Pattersons' twin sons are about to be adopted out despite overwhelming evidence that their conditions are medical, not criminal. This fight is not just about the Pattersons. It's about every family experiencing these same injustices. During the hearings of my bill, SB 304, more than 11 families came forward to testify and over 58 advocates stood with us. The bill passed 3 Senate committees and the Senate floor unanimously and cleared 2 House committees unanimously before being killed in the 3rd House committee after DCF circulated misleading information about the Pattersons. I have done everything the right way, working within the legislative process, bringing forward solutions, and building broad bipartisan support. But without stronger protections and more time for families to prove their innocence, these injustices will continue. The children at the center of these cases often suffer from rare conditions such as von Willebrand's disease, Ehlers-Danlos syndrome, rickets, vitamin D deficiency, clotting disorders, and more. Some premature infants' conditions are worsened by the administration of Pitocin during labor. These children may present with unexplained bruising, fractures, or internal injuries not from abuse but from their underlying health issues. As a nurse practitioner with 34 years of experience, I have seen the horrors of real child abuse. It is emotionally devastating. That is why I initially refused to even review the Pattersons case until I finally did. After months of reviewing the medical records, I saw the pattern. Isolated incidents that, when strung together without context, create the false appearance of abuse. Yet, these same parents often have other healthy children at home who have never had child abuse accusations. The real problem lies in the timeline. Under current law, once a report is filed, children are removed immediately and the hearing is held in 21 days to determine placement. But the specialized medical tests needed to uncover the true cause of these injuries take 6 to 8 weeks per child, plus testing the parents. That means family cannot possibly gather the evidence needed in time and are forced to keep fighting for years. The Pattersons have been fighting since their twins were 2 months old. Those boys are just turning 3. Their children are with relatives who love them, but the boys know their parents and they want to go home. The Pattersons also have a stepson who wants to be reunited. Both parents are highly educated, respected professionals. Tasha is a board-certified gerontological nurse practitioner, and Michael is an administrative IT professional. They have lost their jobs, their financial stability, and nearly everything they own while fighting to clear their names in both dependency court and in criminal court. This is unsustainable. These parents and others like them are fighting for their freedom, their children, and their futures, all because of conditions their children were born with. I have carried this fight as a state senator and as a doctor of nursing practice, but I cannot carry it alone anymore. We need the public advocates, medical professionals, and legal experts to stand with us now before more children grow up without their parents and before more families are destroyed by a broken process. If you can help through advocacy, medical expertise, legal support, or simply by sharing these stories, please contact us at the information provided below. This is not just a legislative issue. This is a human rights issue. We must give families a fair chance to prove their innocence and bring their children home.